Okay, look at the third matter that may be taken judicial notice of court under Section 2 of Rule 129. That those matters that which the judge ought to know by reason of his or her judicial function. Compare that with Section 1. Kasi diba, under Section 1 provides for matters that subject to mandatory judicial notice, right? Section 2, discretionary judicial notice. Section 1 mentions, provides that courts shall take judicial notice of official acts of the Judicial Department of the Philippines. Right? Official acts of the Judicial Department of the Philippines are subject to mandatory judicial notice. Yet, Section 2 provides that those matters that which the judge ought to know by reason of his or her judicial functions, those are only subject to discretionary judicial notice. So don't you see an overlap? Okay, I'm gonna ask you a question. Rules on support issued by the Supreme Court. Rules on support issued by the Supreme Court. Is that subject to discretionary judicial notice or mandatory judicial notice? Saan siya magpo-fall? Section 1 or Section 2? So the Supreme Court promulgated rules on support, right? So saan siya magpo-fall? Will it fall under Section 1 such that courts shall take judicial notice of the rules on support promulgated by the Supreme Court? Or will it fall under Section 2 such that courts have the option to either take judicial notice of those rules or not?
Section 2 po, attorney.
Why? Are those not considered official acts of the Judicial Department of the Philippines? The promulgation of those rules, don't you consider that as official act of the judiciary?
Attorney,
Yes.
in support, attorney, the Rule 129 may apply if the courts
No,
can
Miss,
take...
do you get my question, Miss Ongria? Ang tanong ko lang is, yes, if courts can take judicial notice of the rules, pero ano siya, considered ba siya as mandatory or discretionary? Saan siya magpo-fall? Section 1 or Section 2? That's my question. I'm not asking if whether or not courts may take judicial notice of the rules on support. Ang question ko is the rules on support subject to mandatory judicial notice or discretionary judicial notice?
Attorney,
What provision is... Why?
Because of the existence of the territorial...
Rules on support. Do you get my question? Do you understand my question? Diba I'm pointing out na somehow there is an overlap between Section 1 insofar as official acts of judiciary and Section 2 matters that which the judge ought to know by reason of his or her judicial function. Yes, Miss Larcena.
Attorney, it is mandatory, attorney, because such rules were considered to be official acts of the Judicial Department of the Philippines. And in the provision, it was stated that in Section 1, it is mandatory if it is the official acts of the Legislative, Executive, and Judicial Department of the Philippines. And there is no hearing needed for it to be taken cognizance of by the court. So that is why it is mandatory.
Yeah, do you expect all judges to know the rules on support? Do you expect all judges to know the rules on support?
Such
You don't expect all judges to know the rules on support, but you expect family courts to know the rules on support by reason of their judicial function, because that's what they do. So don't you think it will fall under Section 2? Such that insofar as other courts are concerned, they may not take judicial notice of the rules on support because you can't expect them to know those rules. Yet insofar as family courts, these are matters that they should know by reason of their judicial function, such that they may take judicial notice that such rules exist. Intra-corporate rules. You don't expect family courts to know intra-corporate rules, right? But you expect commercial courts to know those rules. Hindi ba siya magpo-fall under Section 2? Matters that which the judge ought to know by reason of his or her judicial function? Do you see the overlap? Insofar as official acts of the judiciary under Section 1 vis-a-vis matters that which the judge ought to know by reason of his or her judicial function? So what are considered official acts of the judiciary? First is published decisions. Second, MCLE rules. And then the new ULAS rules. Those are considered official acts of the judiciary that falls under Section 1 of Rule 129. Pero yung rules on support, even if it was the Supreme Court who officially promulgated those, hindi siya mag-fall under Section 1. Mag-fall siya under Section 2. Discretionary judicial notice. Why? Because you don't expect all courts to know those. But you expect, for example, rules on support, you don't expect all courts to know those rules, but you expect family courts to be expert on those rules. Same with intra-corporate rules. You expect all commercial courts to know those rules, but don't expect family courts to know those rules. That's why mas magpo-fall siya under Section 2 of Rule 129. Okay. Look at Section 3. So when is hearing necessary insofar as whether or not the courts may take judicial notice? Section 1, okay, matters that are mentioned in Section 1, Rule 129, you don't need hearing for that before courts can take judicial notice of those facts, right? Hindi kailangan ng hearing kasi nga subject siya to mandatory judicial notice. How about Section 2? Is hearing necessary before courts may take judicial notice of the facts mentioned in Section 2. Yes, Ms. Larstena.
Yes po, attorney. In Section 2, since it is discretionary, then a hearing is mandatory because there the court will be exercising its discretion, and hence the parties must be given due process or the opportunity to present or to present the facts, or whether such is truly of public knowledge or capable of unquestionable demonstration, attorney.
Really, Ms. Larcena? What's your basis for saying that hearing is mandatory or necessary in case of discretionary judicial notice under Section 2? What's your basis?
In the provision itself, attorney, since it is purely out of the discretion of the court, then hearing is necessary.
Why? Where in Section 2 does it say courts may take judicial notice of those facts mentioned in Section 2, right? And you're saying that hearing is necessary? Hindi ba the option, the decision is with the court?
Yes, attorney.
So why is hearing necessary?
The court may take judicial notice either motu proprio, attorney. I forgot it. It can also be upon the court's discretion on its own, motu proprio, or upon the request by the party.
But that's Section 3, not Section 2. Ms. Larcena, Section 2 and Section 3 are two different provisions. You're citing Section 3 of Rule 129. Ang tinatanong ko is, di ba, you have Section 2, which provides for discretionary judicial notice. Ang tanong ko is, for discretionary judicial notice under Section 2, is hearing necessary? The answer is no. Hearing is not necessary kasi option siya ni judge. Di ba naka-enumerate sa Section 2 kung ano yung mga, what are the matters that courts may take judicial notice? So the court can exercise his or her discretion insofar as Section 2 is concerned. There's no need for a hearing. The judge need not set the matter for hearing before he or she can exercise judicial notice under Section 2. Okay? Ano yung kaibahan ng Section 1 and Section 2? Hindi kailang, hearing is not necessary. For both provisions, hearing is not necessary. What is the difference between the two? Section 1, walang option si judge but take judicial notice of those facts. Okay? You can compel the judge to take judicial notice of these facts kasi mandatory siya. But for matters mentioned under Section 2, you cannot compel the judge to take judicial notice of those matters kasi purely discretionary on the part of the judge. Yun yung difference ng Section 1 and Section 2. But for both provisions, hearing is not necessary. Now, go to Section 3. When is hearing necessary? So what are matters that may be taken judicial notice under Section 3? What are matters that may be taken judicial notice under Section 3 of Rule 129? matters that are subject to judicial notice under Section 3?
Attorney, it's stated po that the court may take judicial notice po on matters that are material, that are related or are material to the issue of the case po.
Section 3, anong nakalagay sa Section 3?
Yun po, attorney. It's stated po in Section 3 that before judgment or on appeal, the court motu proprio or upon motion may take judicial notice of any matter and shall hear the parties thereon if such matter is decisive from the material issue of the case po.
So, any matter, kahit ano, right? So long as it is relevant. Of course, so long, kasi diba, it must be admissible. So, relevancy and competency. But any matter, you get it? Kahit ano, may be taken judicial notice of the court under Section 3. However, before the court may take judicial notice of that matter, kailangan is-set for hearing. Do you see now the difference between Section 1, Section 2, Section 3? What are the matters subject to mandatory judicial notice? Specifically mentioned under Section 1, right? What are matters that are subject to discretionary judicial notice? They are specifically mentioned under Section 2. For both Section 1 and Section 2, hearing, there's no need for a hearing. In fact, the court is not required to set the matter for hearing before he or she can take judicial notice. However, now you have Section 3. The court may take judicial notice of any matter that is relevant or pertinent to the case in issue, but he or she must set it first for hearing. Yun yung requirement. Before the judge can take judicial notice of a matter that is not mentioned in Sections 1 and 2 of Rule 129, the court must set it for hearing. Now, my question is the hearing referred to in Section 3 of Rule 129, what is the purpose of the hearing mentioned in Section 3? What is the purpose of the hearing? Kasi di ba required yung hearing? What is the purpose of that hearing?
Attorney, the purpose of the hearing is to adjust of the fact if whether or not the materials being discussed are material to the case or are relevant to the case.
So the purpose of the hearing is to determine the propriety of taking judicial notice of the matter. So, for instance, okay, for example, there was a stabbing incident. Okay, so may nagsaksakan. And the only light that allowed the witness to identify the perpetrator was the light of a full moon. Okay? So, question, may the court take judicial notice that at the time of the commission of the crime, there was a full moon? So, again, listen, there was a stabbing incident, right? And the only light that allowed the witness to identify the perpetrator was the light coming from a full moon. So, sinabi niya, nakilala ko yung perpetrator. Nakilala ko kung sino yung sumaksak kasi maliwanag yung buwan noong gabing iyon. That was the testimony of the witness. Now, question, may the court take judicial notice of the fact that at the time of the commission of the crime, there was a full moon?
Yes po, attorney. The court may take judicial notice po.
Which provision is the applicable provision? Is hearing necessary before the court may take judicial notice that at the time of the commission of the crime there was a full moon?
I'm sorry, attorney. What's the question again po?
Is hearing necessary before the court may take judicial notice that there was a full moon?
Yes po, attorney. The hearing is necessary po.
Why?
Because there was relevant information that the witness was able to see the perpetrator commit the
Before that, Mr. Montario, you have to establish muna na that there was a full moon does not fall under Section 1. It neither fall under Section 1 nor Section 2. You get it? Kasi kung mag-fall siya under Section 1 or Section 2, then hearing is not necessary.
Yes
Bakit
po.
pumunta agad sa Section 3, right? That's why it's very important for you whether or not, kasi kung ang tanong is whether or not hearing is necessary, you have to identify first what is the applicable provision. Is it Section 1, Section 2, Section 3? If the applicable provision is either Section 1 or Section 2, then hearing is not necessary. Hearing is not needed. But if it falls under Section 3, then hearing is necessary, as mandated by Section 3, Rule 129 of the Rules of Court. Okay, so during the hearing, what are the pieces of evidence that will be adduced? Kasi di ba ano yung purpose ng hearing? To determine the propriety of taking judicial notice of the matter of the fact that there was a full moon at the time of the commission of the crime. So what are the possible pieces of evidence that will be presented during the hearing? Kasi di ba you're asking the judge, you have to take judicial notice. We don't have to prove ano ba yung importance once the judge takes judicial notice that at the time of the commission of the crime there was a full moon. So ibig sabihin maliwanag yung time na yun. So if maliwanag, there is a possibility that the witness can clearly identify the perpetrator, right?
Ganun po kasi. Ganun po.
Yes, Mr. Sanchez.
Hello po. Yes po, attorney. I will present po, attorney, a testimony or documentary evidence from meteorologist from Pag-asa stating that at that specific date that there is a full moon po, attorney.
Okay, so you have to establish that there was a full moon at the time of the commission of the crime. The opposing counsel naman may establish that it was not a full moon at the time of the commission of the crime. Okay, so nabasa niyo naman yung slides, right? So I don't have to discuss this one. Judicial notice of proceedings in another case. So as a general rule, a court is not authorized to take judicial notice of the contents of another case even if said case was heard by the same judge, kahit na that same case is pending before the same judge. But that rule admits certain exceptions. Okay, so what are the exceptions? Then you may read the exceptions flash on your screen. So, admissions. Section 27, Rule 130 defines what an admission is. Okay? So, admissions. An admission is the act, declaration, or omission of a party as to a relevant fact may be given in evidence against him or her. An admission is a party's acknowledgement of a fact which is against his or her interest. Okay? So the concept of admission is both applicable to civil and criminal cases. Why is that important? Kasi later on, we will discuss confession, and the concept of confession is only applicable to criminal cases. There is no, the concept of confession is not applicable to civil. Pero admission, it's both applicable to civil and criminal cases. There are two kinds of admission, okay? You have judicial admission and extrajudicial admission. Okay, so a party may make an admission in any of these ways. So there are three ways on how a party may make admission. So first, in written pleadings, motions or other papers and stipulations filed in relation to the case. Second, in open court, either by his testimony on the stand or by his statement or that of his counsel. And third, in his or her statement made outside the proceedings in the same case. So for the first two kind of admission, you call that judicial admission because the admission is done during judicial proceedings, during court proceedings. So for number 1 and number 2, they fall under judicial admission. For number 3, yan yung tinatawag ninyo na extrajudicial admission. Admission that is made outside the court's proceedings. Okay, so for judicial admission, what is the rule? So judicial admission is any type of admission made in the course of the proceedings before the court. Also, any document submitted in court. So ito yung mga pleadings, motions that you submit before the court. If they contain statements that may be considered as admission, then you call that judicial admission. Okay? Do you need to prove that? The answer is no. Why? Because judicial admissions require no proof. And they are admissible in evidence. Okay? So, examples of judicial admission. The defendant admitted in his answer that he signed the contract. Then that is an admission. Another example of a judicial admission is that. So what is the consequence of the defendant admitting that he signed the contract? Then the plaintiff now no longer needs to prove execution of the contract. Okay, because the statement of the defendant that he signed the contract becomes a judicial admission, and judicial admissions require no proof. Hence, the plaintiff no longer needs to prove execution. How about extrajudicial admissions? Those that are statements made by a party outside the proceedings in the same case are considered extrajudicial admissions, which may be an act, declaration, or omission made by a party as to a relevant fact and may be given in evidence against him. This type of admission is regarded as evidence and must be offered as such. Otherwise, the court will not consider it in deciding the case. Okay, so there are various rules governing extrajudicial admissions. Okay, so if the extrajudicial admission was made before a public officer, then ito yung rule. If admission is made while in court custody, rules on custodial investigation should be followed, meaning the admission must be in writing with assistance of counsel, and should the requirement of counsel be waived, it shall likewise be in writing and with the assistance of counsel. Okay? So, if the admission was made before a private person, then the person to whom confession was made will have to testify as to the fact that the person disclosed it to him. Okay, so this private party before whom the admission was made, that private person must appear in court. Okay? That private person must testify that the defendant, the plaintiff, or the party in a case admitted some facts. Okay? Pero yung testimony ng private person na to, he or she will only have to testify as to the fact that the person disclosed it to him. Okay, now confession. What is confession? Take note that if admission is applicable to both civil and criminal cases, confession is only applicable in criminal cases. Okay? What is confession? Confession is a declaration of an accused by express wording of law acknowledging his or her guilt of the offense charged. Basically, it pertains to the plea. Okay, whether or not he or she is guilty of the crime charge. Okay, admission does not, ito yung sinasabi ko na may distinction between confession and admission. Admission does not necessarily go into the guilt of the accused. As compare that with confession, which is the acknowledgement of one's criminal liability. Take note also that barangay tanods and bantay bayans are considered auxiliary law enforcement officers. Okay? When a person is detained or restrained by them in connection with the investigation of a crime, the situation may already fall under custodial investigation. Hence, the rules on custodial investigation shall be applied. Okay, again, offer of compromise. When does offer of compromise happen? Okay, in civil case, you have pre-trial, right? Tapos na ba kayo sa CivPro? Are you done with CivPro?
Yes po, attorney.
Okay. So, civil case, during the pre-trial, usually, the defendant will manifest his or her willingness to compromise. Okay? But if there is no manifestation of the defendant's willingness to compromise, then the case will proceed to pre-trial proper. But even then, ibabato pa rin siya ni judge sa court-assisted mediation and after that, sa JDR. Okay, so maraming opportunities wherein the parties may reach a compromise. How about in criminal case? Okay, the offer of compromise usually happens during pre-trial proper. Okay, and then if there is no manifestation that the parties are willing to enter into a compromise, then ibabato pa rin sila ni judge sa mediation. Pero kung wala talaga sila ma-reach during the mediation, then trial will proceed. Okay? So take note, offer of compromise can be made at any stage of the proceedings. Okay, what's the rule with respect to offer of compromise? In civil cases, as a general rule, the following are not admission of any liability and are not admissible in evidence against the offeror. Okay, so the offer of compromise. So when the defendant made an offer of compromise to the plaintiff, that will not be considered as an admission of any liability. And in fact, the fact that the defendant made an offer of compromise shall not be admissible in evidence against the defendant. Okay? Also, conducts or statements made during the compromise negotiations, those are not admissible in evidence. Okay? Against the offeror. But there are exceptions to that. This rule admits certain exceptions. Okay? So meaning, they are admissible in evidence against the offeror. So what are the exceptions? First, when the evidence is discoverable in some other way, or the evidence is offered for another purpose. Okay, such as, okay, so these are the possible purposes wherein the evidence may be offered to prove bias or prejudice of a witness, negating a contention of undue delay, or proving an effort to obstruct a criminal investigation or prosecution. Okay, so these are the exceptions, which makes offer of compromise as admissible in evidence against the offeror. Okay, how about in criminal cases? As a general rule, an offer of compromise by the accused may be received in evidence as an implied admission of guilt. This is totally different from the rules on offer of compromise in civil cases, right? Because it's not, in civil cases, offer of compromise is not an admission of any liability. But in criminal cases, an offer of compromise with the accused may be received in evidence as an implied admission of guilt. But there are exceptions to that rule, meaning an offer of compromise is not considered as an admission of guilt. So what are the exceptions? Those involving quasi-offenses, meaning criminal negligence. So what are these offenses? What are the quasi-offenses? Reckless imprudence resulting to damage to properties. Reckless imprudence resulting to physical injuries. Those are quasi-offenses. Okay, so kung ganun yung offense, if it involves quasi-offense, then an offer of compromise by the accused shall not be considered as an admission of guilt. Another exception are those allowed by law to be compromised, meaning estafa, the crime of estafa. The law allows estafa to be compromised, right? So if the accused made an offer of compromise, then that offer of compromise will not be considered as an implied admission of the accused's guilt. Another exception is a plea of guilty later withdrawn, or an unaccepted offer of a plea of guilty to a lesser offense. Another exception is that any statement made in the course of plea bargaining with the prosecution which does not result in the plea of guilty, or which results in the plea of guilty later withdrawn, and this one becomes inadmissible. Okay? So take note lang yung differing rules on offer of compromise, whether it's done in a civil case or in a criminal case. Okay, there are three types of evidence under the rules of court. Evidence may be classified into three. You have object evidence, documentary evidence, and testimonial evidence. I think you can find this under Rule 130 of the rules of court. So when you say object evidence refers to physical objects addressed to the senses of the court. So examples of object evidence are weapon used in crime, blood-stained clothing, and fingerprints. Okay? Okay. If it involves object evidence, then authentication is mandatory. Authentication of the object evidence is required. Okay? So how is authentication done? The witness must testify that the object is what it is claimed to be. For example, the knife was the weapon used in committing the crime. For example, stabbing incident. And they were able to recover a bloody knife. So the bloody knife will be presented as an object evidence, right? Since it is presented as an object evidence, then it must be authenticated. Who will authenticate that? The person who recovered that knife. And how is authentication done? The police officer in charge will identify that the knife being presented in court is the one that is recovered from the scene. That's how authentication is done in court with respect to object evidence. Okay. Authentication is very important with respect to chain of custody. Naririnig ninyo yung chain of custody, but usually chain of custody, naririnig nyo yung chain of custody in relation to drug cases. But chain of custody is not exclusive to drug cases. Chain of custody is also applicable to audio or video recordings. Okay? So for instance, if the evidence that you want to present in court is audio or video recordings, then you have to establish that from the time the evidence, so how do you establish chain of custody? That there was no break insofar as chain of custody is concerned. You need to establish that from the time the evidence was taken, there was no break in the chain of custody that may have caused the object to be tampered with or switched. Okay? So you have to prove na walang break. The opposing party naman will have to establish that there was a break, such that there was an opportunity for the object evidence to be tampered with or switched. Okay? So how do you establish that? How do you establish the chain of custody or that there was a break in the chain of custody? Okay, so first you have to present your witness. And usually, ano yung mga questions that will be asked? So, who took the recording? And then, what will be the answer of the witness? I did. And what material did you use? What equipment did you use to take the recording or to record the happening? So sasabihin niya na, I use a cassette recorder. Does the cassette recorder have the ability to capture audio conversation? So you have to establish that the machine has the ability to capture what is to be presented and how it was recorded. And you also have to establish that it was not subjected, that the video or audio recording was not subjected to splicing, editing, or deletion. Okay? And lastly, you have to establish who was in possession of the recording up until it reached the official custodian. That's how you establish chain of custody or break in the chain of custody. Okay, so if there is a break in the chain of custody, what will happen? Well, it will affect the authenticity of the evidence. But take note, so if it will affect the authenticity of the evidence, will it automatically become inadmissible? Will it become automatically inadmissible if you were able to show that there was a break? So, diba, you have to establish chain of custody. Suppose the opposing party was able to establish that there was a break in the chain of custody. So, it will affect the authenticity of the evidence, right? So, ano yung magiging consequence nun? Will it become inadmissible? Will it automatically become inadmissible? Will the evidence become automatically inadmissible since there was a break in the chain of custody?
No po, attorney.
Why not?
If that party po will be able to justify such break po, attorney, then the court may still consider po.
So as a general rule, it becomes if party was able to demonstrate a break in a chain of custody, then it affects the authenticity of that evidence and it becomes inadmissible. However, if the other party can explain, so for example, the accused was able to show that there was a break in the chain of custody of the drug. It's a drug case. So there was a break in the chain of custody of the drug. Okay? Kasi gusto niya matapon, mabasura yung drug as evidence. So, kailangan niya mapakita, ma-establish that there was a break in the chain of custody. And the accused was able to show a break in the chain of custody. Does it become automatically inadmissible? Ibabasura ba agad siya ng korte? The answer is no. Why? Kasi the plaintiff may offer a justification or an explanation of that break. If the plaintiff or the prosecution, since it's a criminal case, if the prosecution was able to explain the break in the chain of custody and was able to justify the break in the chain of custody, then the court may still consider the evidence at hand. Okay? That's how it works. So you have to justify. Pero mas mahirap yun. But it does not automatically mean that the court will no longer consider the evidence.